Helen Ryan, and I am the Executive Director here at the Cannabis Alliance. Again, I want to welcome everybody for coming today. Here at the Cannabis Alliance, we are dedicated to the advancement of a vital, ethical, equitable, and sustainable cannabis industry. And we've just had a really big sort of fundamental shift in commercial cannabis here in the United States of America. And in Washington, we are trying to figure out how to navigate that. Um, uh, just recently was at Interchange. For those of you who are not in Washington State, that's a B2B event that we have here in Washington State, and had the opportunity to talk to a lot of licensees. And I know that so many of you have questions. I've also been in contact quite a lot with our Attorney General's office, the Liquor and Cannabis Board, the Department of Health, have been working with some legislators to try and understand what the state's position is going to be on the order put out by the Department of Justice a little over a month ago now. So far, we have not had any official statement from the state of Washington beyond sort of an acknowledgement that they are aware that this order has been issued and that they are trying to understand what it means for the state of Washington. At the Cannabis Alliance, we've been advocating for the state to come up with sort of a defensible definition of what medical means, so that if people want to apply to register with the federal government, they can. I don't know that we're going to get that. Certainly not by the end of the 60-day window. And we're going to talk about all of those details here in just a minute. But what I want to say before I turn it over to our esteemed panel here is that this webinar today is for educational purposes. I think it is our number one goal to ensure that you all have as much information as you possibly can to make a decision for yourself. There is a reality where one licensee may choose that it is not the right decision for them to register with the DEA, and then another licensee might make a completely different decision, and both of those would be reasonable decisions. And so we can't tell you what it is that you need to do. But again, our goal here is to arm you with as much information and as thoughts from very, very smart people to help you make the decision for your business. And then, of course, some lovely folks that if you'd like to talk to them after the webinar to help you go through the process in more detail, we can absolutely do that too. We are going to make sure that we have 30 minutes for questions at the end. So feel free to go ahead and put them in the chat as well. We may also take a pause here or there to answer some questions as they come through, but we want to make sure that you all have the opportunity to interact as well. So to begin with, I would like to turn it over. Everybody's going to have the opportunity to do an introduction, but I think maybe to start with, let's go ahead and just lay the foundation of understanding about what the order is. Hannah, if you wouldn't mind, though, starting us off with an introduction, tell us a little bit about yourself, and then if you could tell us just again that foundational understanding of what the order is and what we know about it so far.
Yeah, absolutely. Thank you. And thank you so much for inviting me to participate in this panel. My name is Hannah King. I'm a cannabis attorney with Dentons. Dentons is a global law firm. It's a full service firm, but we have a global and a national cannabis practice. There are about 10 attorneys that are full-time cannabis and licensing. I've been doing work in the space since 2013, 2014. I represent just under 500 clients across the country, mostly touch the plant clients. And we've been doing a lot of work at Dentons, kind of like everyone else. There are a lot of smart people thinking really hard about what does this order mean. But we thought that it would be helpful just to give a really high level introduction of the order before we started kind of the panel discussion around it. And so I'm going to do that. So I think everybody knows that on April 23rd, the Department of Justice issued an order. The order was actually executed on April 22nd. But that order created a new class of cannabis called medical cannabis and rescheduled cannabis that fell within that class of medical cannabis from a Schedule I drug to a Schedule III drug effective immediately. Within that new class, that class of medical cannabis are two different types of products. So the first is FDA approved products containing naturally derived cannabis. Those don't exist right now. All of the FDA approved products that we have contain synthetic cannabis or naturally derived hemp. But the other class is medical cannabis and cannabis products that are produced pursuant to a state license for medical purposes. And so the order itself doesn't do anything for cannabis more broadly, so for recreational or adult use cannabis. It did cancel the administrative law judge hearing that has been kind of sitting in purgatory since the judge retired and scheduled a new administrative law judge hearing for June 29th. That is supposed to be an expedited hearing. It's supposed to be finished in 45 days. So they're essentially continuing that process, the broader process of rescheduling cannabis more generally. And so this order really just affects medical cannabis. One thing that I think is really helpful context is understanding the two different ways that the federal government can reschedule a substance. So the first way is the way that we've been going through since President Biden issued the executive order, essentially kicking off the rescheduling process. So that is the Department of Health and Human Services does an evaluation of kind of the medical and scientific data and makes a recommendation. Then there's a notice and comment period. In some instances, there is an administrative law judge hearing, and then there is either a final order adopted rescheduling or there is no final order and the substance stays on the schedule that it was on before. So that's one way. The second way is that the Controlled Substances Act authorizes the Attorney General to unilaterally, without going through that process, reschedule a substance when they determine that it's necessary to comply with certain international treaties. So in this order, what Acting Attorney General Todd Blanche said was, I am determining that it is necessary for me to reschedule medical cannabis, so as I've defined it, from a Schedule 1 to a Schedule 3 drug in order for the US to continue to maintain its obligations under the Single Convention of 1961. And in addition to that, what he said, and I tell people where this is in the order because the order's long, it's complicated. It talks about federally FDA approved drugs, and then it talks about state cannabis licensees. But on page 21 and 22, the order talks about how in order to comply with the treaty, not only does Attorney General Todd Blanche believe that they need to reschedule cannabis, but also that regulation of cannabis needs to change going forward. And there's this discussion about the federal government doing an evaluation of state programs, determining that as a whole, states have put in place robust regimes for protecting public interest, protecting against diversion, protecting public health and safety, and that they really have no intention of disrupting patient access or existing supply chains, but that in order to comply with the treaty obligations, that the model going forward is going to be a co-federalism model. And so a model where states continue to issue their own licenses, and the operators within those states continue to follow the laws of those states, and the state regulators continue to enforce those laws, but that the DEA would also issue DEA registration. And so when the DEA determined, or if the DEA determined that there were certain public interests, it was in the public interest to revoke or deny a license, they would have the authority to do that. And what the order goes on to say is that in order to facilitate this transition, that they're creating a new expedited DEA registration process for state licensed medical cannabis businesses. And that if folks file within 60 days of the order being published in the Federal Register, which we just got some additional guidance saying that they see that as being June 26th, then there's two things. One, the order includes language that says you can continue to operate with your state license while the DEA registration is being processed. And two, you'll be part of this kind of expedited review process, which they say aspirationally will be completed within a 6-month period. And so that is kind of a high level summary of what the order says.
Thank you so much, Hannah. I think to I'll save this question for later. Let's go ahead and dive in with further introductions. And maybe Hannah, you can, or we'll come back around. Chris, maybe you can start us off. But I would love for you to introduce yourself and tell us a little bit about who you are. And then also our opening question: if a Washington cannabis business called you today and asked whether they should apply, what's the first thing you'd want them to understand before they made that decision? So again, we're not giving anybody any advice, but what are the considerations that are atop of your mind when you are getting that phone call? We'll go Chris, Alexis, Mitzi, and then Drew.
Man, that's kind of the $1 million question just to start us right off, right? So
Yeah.
let me start with a little introduction to me, and then we can dive into the specifics on this. Hi, I'm Chris Lynch. I'm a partner at Dickinson Wright. I'm based out of our Seattle office. We're a national full service law firm. We've got a robust cannabis practice here across the US. I think for professionals that have touched on these issues, we've got more than 60 plus. We've got a core of about 10 people. I've been doing this longer than a decade, and most of the people on the team have been also doing it in that same time frame. We've got some people who've been doing this for 13 or more years, so we've got a lot of history and a lot of experience here. We touch on everything from working with businesses and investors and service providers on mergers and acquisitions, financing, public offerings, regulatory practice, commercial transactions, the whole gamut. So if you're coming across it, we've touched it almost certainly. Um, to answer your question, right, what's the first thing you want them to know? I think where I am falling right now, whether or not you apply is really a business judgment on your part. I think everybody on this panel has a little bit of a different take on, do you have to apply? Should you apply? When should you apply? And what the risk of doing that is, right? Um, you're going to have to be, if you're going to apply, the first thing you're going to have to do is get comfortable stepping into the unknown again. And I appreciate that's a little bit of a rich thing to say to this group who has consistently done that over and over and over in this industry. And I think we're on another one of those thresholds. We'll talk about all of these things. So I kind of don't want to, bury the lead or steal anybody's thunder about what we're going to talk about today. But there are pretty robust disclosures you have to make about your employees, about criminal history, about your suppliers, about kind of all kinds of things. We have a question about mixed use licenses in Washington state that makes this more complex than if you have a medical only license in a medical only state. So that I think is my first question is, are you comfortable or can you get comfortable with what this process is going to require?
Thanks, Chris. That's a lot of information. My name's Alexa, and there's a lot that we have to discuss today. So, my name is Alexis Hartwell-Gobeski. I'm with Dynamic Law Group. We're a teeny tiny little law firm out on the west side of Washington. I've been working in cannabis since 2014, both in California when it legalized and in Washington. And so I have sort of this dichotomy of seeing what it looks like in a state where registration probably makes a ton of sense to, what does this look like here in Washington where we have this weird mixed use component and, not a clear framework or pathway. So there's some really big talking points that we're going to go through today. So I'm going to focus on something a little bit more granular. If somebody were to contact me today and say, what do I need to know? And I think one of the most important things for them to know is that if they register, they will be operating in a closed loop system, which means in Washington, you're limited to the suppliers that actually also register. Medical is a relatively small component of our industry here in Washington. So, there is a very real chance that your suppliers don't register. There's a very real chance that even if you register, I mean, what percentage of your actual business is focused on medical cannabis? And are you planning to intentionally expand that component so that registration makes a lot of sense for you? Or is this something that you're just hoping that you will register for so that potentially someday in the future you can engage in interstate commerce? It's it's an interesting question. What will it look like for medical when it's such a small percentage of our industry?
That's a lot of information. No, all of it's a lot of information. My name is Mitzi Vaughn. I've been representing the Cannabis Alliance from the day it was founded. I've been practicing in Washington and for a while in California and Hawaii in cannabis since 2013. I'm one of the founders of the International Cannabis Bar Association. I have done work with the state legislature, with the LCB, with national governments, Congress, and international governments like Haiti and Ireland, actually. But I also was a professor for a while of legal writing and research. And so I'm very word obsessed. And so that's part of where I'm coming from when I start talking about this order. The thing that I think is really important, particularly for Washington businesses, is to understand that the language of the order does not make clear whether or not it is required or not. And if an agency is going to be regulating you, they need to do it with clear rules to do so. And so the rules are pretty clear on the process, but at no point does it say that anyone is required to apply. And in fact, the way it's listed, so Schedule 3 is actually a schedule. So there's the Controlled Substances Act, which is based, thanks Hannah for explaining some of this too, on the Single Convention. And then that has like an attachment basically for each schedule. And so the language that actually got put on the schedule is just, what is it? Sorry, it's right here. I'm going to scroll down. It's marijuana, yada, yada, as FDA approved, which Hannah talked about, or subject to a state medical marijuana license. That's it. They don't say registered state medical license. They don't say anything else. So from a kind of academic standpoint, I think that I feel like you have a very strong argument that it's not required in the first place. When you figure in also this regulatory situation in Washington, we go back to the language again, right? Because it says state medical marijuana license. And we have licenses that don't specify. So when that is the named evidence in the order, which is now in statute or rule, then how do we deal with that? And the Cannabis Alliance has been, great. I actually wasn't much part of this, so I'm not tooting my own horn. And really trying to work with the state to try to figure out what we could do about the fact that we don't have a definitive one way or the other license. And so that's a problem right now. And, being old school and having, attorney friends of mine be raided and subpoenaed and threatened with criminal prosecution and, whatnot. I hesitate individually to think of myself giving information to the federal government that I don't have to. And I'm not saying that I'm a big time rule follower, but like if I don't have to do it, I'd rather not do it. So those are all considerations, but the flip is, and other people will talk about this more, there are potential benefits. It's just, we don't know what those are. It doesn't say right now. And so everything, both good and bad, is completely speculative based on this little language, which seems like a long order, but in the end, what's important really isn't. And we're all kind of doing the best we can to figure out, okay, what's the risk? What's the benefit? Where are you, the client, the person out there? Where are you situated? How do you feel about filling out a government form? Or are all of your suppliers DOH? Are you all on board? Because that closed circuit, I think, is super important, Alexis. And I'm really glad you said something, because that gets overlooked. If you register, you can only buy from other registered people. Right now, that registration is only for retailers. So you don't know who's going to register. or, they could say they're going to, but you don't know. And then also, have you asked those people if you can list their name? If maybe they don't want to be on your application. So there's some practical considerations there too. But there are a lot of interesting potential benefits that I'm going to punt to someone else to talk about. But it's a very, very individual calculation. There's no right answer. And it hurts lawyers to say that a lot.
Thanks, Mitzi. I think it's my turn to introduce myself. Hi, I'm Drew Davis. I'm a solo practitioner. I've been practicing in the cannabis space since 2015. I've been practicing quite a bit longer than that. I mostly work with producer processors. I work with some retail. And from what I'm seeing about this, I do a lot of administrative work. And this isn't legal advice, but just in general, working with administrative agencies, it doesn't ever get easier. And right now, it's easy comparatively to what it will probably look like. So if your company feels ready and you feel like you have your ducks in a row and it's a communication that you don't mind putting out there, you're not worried that you're a social equity applicant and you have a criminal record that they may treat differently. You're not worried about some things that may pop up with the DEA and you feel comfortable applying. If I was in your shoes, I would. And it's simply because it's not going to get easier. It's not going to get faster. Administrative agencies rarely do. And right now, when I'm putting these applications in, I'm actually communicating with individuals via email. I'm sure within a year it's going to be an AI algorithm and they're just going to kick it out because Washington is a weird system. I can't just say, here's my medical license. You guys have a picture? We're good, right? It's not working like that. I have to explain how our system works and what we're doing to make it work. And I need somebody at the DEA to look at it and understand that and say, oh, okay, this person's trying to comply. And it looks like what they're doing and what they're submitting is compliant from that perspective when I look at it. But without an actual human touch, I don't know how easy it's going to be if you're a Washington State company. But my advice is really Washington State specific. That's where I practice. It's the only place I practice. And it's the only place that I see people doing this. So if I was a Washington State business at a personal business standpoint and I felt comfortable, I would apply because I don't think that it's going to get faster or easier. And I think there are very good potential benefits, especially from the tax arena, that could be incredibly beneficial for businesses down the road once our state figures out what they're doing, which is going to be a minute. Anything from the LCB or the governor's office or literally anyone from the state confirming how our licenses work would be really helpful. Just some kind of official memo, letter, memorandum, email, something. If anybody from the state is in this, please just send an email that says, hey, we recognize you as a medical business. That would help us with the DEA. But just us explaining, here's how our system works is a lot of work and it's a hope and a prayer. And it would be a lot nicer if it wasn't and we had a separate system, but we don't. And our state is not taking any emergency actions to help our businesses, and they should be because we bring in a lot of tax revenue. So that's my 2 cents on this.
Thank you, Drew, and thanks for the advocacy there. Hannah, what do you wish? What's the fundamental thing that you wish people would take into consideration when they're working on making a decision?
Yeah, so when a client calls me and asks me about this, I will say that it is our firm's position that we understand this to be mandatory, but that there are business considerations and each company needs to really evaluate what are the pros and what are the cons. And so when I'm talking to clients, some of the pros are this is federal legalization. If you have a DEA registration to manufacture, cultivate, or sell cannabis, you are doing it in compliance with the CSA and federal law. So what doors does that open for you? Federal trademark protections, bankruptcy protections, uplisting opportunities. I mean, we're engaging right now with NASDAQ and New York Stock Exchange. I think folks have seen that there are some uplistings happening. That is directly connected to the fact that this is viewed as federal legalization. There is the opportunity to export to countries. There's potential future opportunity for interstate commerce, banking, credit cards. Insurance companies are starting to consider whether or not they would cover products that are produced by the state licensed medical operators with DEA registrations. So there are a lot of benefits. But then there are also cons, right? Like I think Mitzi did a really good job of laying out some of the considerations for potentially that would lead you to not file. But the other thing that I want folks to consider is, you know, the language in the order does say, if you file within the 60-day window, you can continue to operate just under your state license. We don't know what DEA is going to do, but there is certainly a suggestion there that the inverse is if you don't file within the 60-day window, perhaps you can't operate just under your state license. The way that we kind of viewed this order was the thinking was we don't want to interfere with these state programs, but we want the federal government to have a little bit of oversight. And the thinking was, folks are just going to file for DEA registrations because it's really not going to change their day to day. So it's not going to disrupt. I mean, this is the federal government not understanding the reality of cannabis, right? So it's not going to disrupt supply chains because everyone within your supply chain is going to have a DEA registration. And that isn't the reality. It is the case, Mitzi, we are advising our clients to go talk to your important vendors, have a conversation about this, make sure that you understand. I do think, like Drew said, you're not the only state where there are dual licenses that do not expressly say medical, and that essentially it's a very similar model, Maryland, Ohio. And so we do not think that precludes folks who are producing cannabis that pursuant to a state license that is being purchased by patients, right? That's medical cannabis being used for medical purposes. But really do encourage people to be talking to attorneys who can help you figure out, how do I explain? Because it is the case that you will not be able to just submit a license that doesn't indicate that it's medical and not do anything else. There's going to have to be some additional follow-up. But I just think it's really considering, your business better than anybody else. What are the cons of not doing it, and what are the cons of doing it and doing that analysis and getting comfortable?
So what a great bridge, Hannah. Thank you so much. I want to open it up to that sort of, to quote William Shakespeare, to apply to the DEA or not to apply to the DEA. That is the question. We've already sort of danced around it a little bit, but I want to open up to just open discussion amongst you all. What are those considerations? What is the universe where it looks like this is probably not a good idea versus probably we should? Like I said, we're hearing that a lot already in some of this opening part. But what else would you like to add to that discussion?
If you wouldn't
Yeah,
mind.
Mitzi, go ahead.
So from a practical standpoint, part of the order, and this is part of the treaty obligations, to keep going back to that, is that the DEA has to basically come in and do a sham transaction where they buy and sell to be in the middle so that they have this kind of picture of control, which is required by the treaty. And so what I keep thinking about, and I'm really interested in what everybody has to say here, is that here you have DOH compliant product, but anybody could buy it. And so what are you selling, what are you buying and selling for the DEA that you're saying is medical when it's manufactured for medical? But I really liked Hannah's language was it's purchased by patients, right? That's easier to track. It's purchased by patients. And if you didn't have the DEA inserting itself necessarily, it's not the DEA's fault, into the process, it'd be different, but they are. And so you're talking about this process beforehand that really affects Washington businesses. And I want to make super clear that like a lot of what I'm saying would not be even something I'm thinking about if we were in Oklahoma and had only medical, if we were vertically integrated, right, to the point about supply. But we're in this spot right now, and all of us know, I believe, that it's the same plant. And so it's the same plant. And so when you're trying to figure out what you're going to sell to the DEA, to sell to the retailer, to, that is going to be medical marijuana as opposed to other marijuana, how are we going to do that from a practical standpoint? And so that's when we start getting into practicalities. It's like, okay, let's think about how this will work. And it's that kind of logistical issue when, the DEA doesn't want to be buying, a Schedule I drug, because if it's not consumed by a patient or sold as medical, then it's still Schedule I. And so how are we going to deal with that? Putting aside all the kind of intellectuals discussion.
So we've worked on DEA registrations for cannabis businesses, cannabis cultivation and manufacturing for research purposes. So this was the kind of standalone DEA registration that was available. These could not be state licensed operators. And that is where this requirement that the DEA like comes in and purchases it and then it is distributed from there. It really is it's pro forma. It's not we're not expecting it to disrupt operations. It really is, at least in practice right now, and it's on a much smaller scale, right? There's not the folks who are producing pursuant to these research licenses are producing smaller amounts and it's going to very specific people, but it really is, DEA is not coming to your facility. DEA has the authority to go to your facility, which is where the control comes in. And so I'm not expecting it to be particularly disruptive to the supply chain. And Chris, I don't know if you've done these or have thoughts about it.
I'm of the same opinion. I think the language of the order includes language in there that the administration, meaning the DEA, has access to the facilities where you store these products, but I'm not anticipating that it's going to be a ship it off to Mississippi and then they touch it and then send it back to you to go to the retailer kind of situation. I mean, to the top of the hour, right? We're dealing with a ton of ambiguity here. We don't really know how this is going to go, but I think it's a reasonable assumption based on the information we have, based on admittedly unofficial conversations, right, that we're having with the DEA. And I know you've had a couple of these conversations as well. I suspect more than a couple. What they're telling us unofficially is they're not trying to disrupt state systems and they want to do what they can by state actors who are trying to be compliant. I cannot emphasize enough, and I'm sure we will say this a couple more times in this webinar, these are unofficial statements. We don't have really good direct guidance on these things, but that seems to be where we're going. And I will confess, when the order first came out, I was really pessimistic. I really read it as not really helping Washington businesses at all. And it was going to be a much more complex thing. And really, some of these conversations that we've had with the DEA over the last couple of weeks has really softened me on that. And I do think now where we sit, it's worth pursuing, if nothing else, getting the information together to decide kind of as we come up. And we can talk about this a little bit more if anybody has questions about it. But we're starting to see the portal collapse a little bit under the weight of these applications. So I would recommend that if you're going to do this, don't wait until June 26th to do it in case you can't get the portal to go through. Start thinking about this more now so that you have more runway to do it. But that's, sort of a little bit of an aside there.
I have concerns, though, about whether or not our state system as it exists even comports with the requirements, though. And I mean, maybe Chris and Hannah, you have a perspective on this, but we don't have clear separation. All of my producer processor clients are growing 100% recreational. There's not really a separation of facility. There's not a separation of bookkeeping. There's not a separation of traceability for a medical component. And so there would be some level of disruption. And from a practical perspective, I anticipate applicants for registration having to do some substantial overhaul of their SOPs in their facilities. Have you seen different?
So I
think it's a risk. And sorry, go ahead, Anna.
No, you go ahead. I apologize.
I was just going to say, from the Washington perspective, we're taking the position that a medical endorsement is sufficient for purposes of demonstrating medical compliance. There is definitely a question about the co-located or mixed licenses. And Hannah, I know you'll talk about some other states that I know you've got clients in that have kind of similar situations. But what historically the DEA system is closed, right? And what they have told us really up until the last couple of weeks is their enforcement tool is a hammer, not a scalpel. If they see violations of federal law, they have to do something with that. And so over the last couple of years, we had other people apply for DEA registrations, mostly for research purposes. And the DEA said, look, if you are going to do state compliant but federally illegal activity, put that in a different facility. You need all new equipment, all new locations, all separate books, all separate records, all separate bank accounts. All of that needs to be completely isolated. We are now hearing kind of for the first time unofficially that they're going to be a little bit more relaxed on that from a mixed use perspective. Do I think there could be issues there on having to do new SOPs, having to have separate secure access, right? The application, we can talk a lot more about this language, and there's a lot of ambiguity there, so we can certainly talk about it. But the registration application says you have to disclose a lot of personal identifying information and criminal history for employees who have access to controlled substances, right? Very reasonably, somebody could read that as meaning everyone in your business, right? If you have access to it. Could you, in theory, set up a different secure room where you keep DOH product and only limit that to certain employees? Sure. Can you is a very different question there. But Hannah, I would love your thoughts on that as well.
Yeah, so I was just gonna, before we got on the panel, Caitlin and I were talking about, so I'm actually physically located in the state of Maine, and Maine is unique because our medical program has no tracking and no testing requirements and no record keeping requirements. And so there was some thinking initially that all Maine licensed, there were registrations in Maine, registered medical operators in Maine might be precluded from getting a DEA registration. And what we're hearing now is what DEA is saying is considering is, well, there are certain federal standards that apply to other DEA registrants for record keeping and for tracking. We're not going to apply those to folks who have to states that have seed to sale tracking. You know, I was talking to Caitlin, if you can take those record keeping requirements in Washington, take a look at your tracking program and make an argument that the way that your state Washington requires you to track complies with the record keeping requirements, that would be something that I'd recommend doing. But in Maine, it sounds like what they're going to do is just require that the operators here follow those record keeping requirements. And so I think we are seeing a level of flexibility that I've never seen from the DEA before. The other thing too is that both the order and the guidance that came out from the Treasury recognizes that you are going to have single businesses, single taxpayers that are selling both and producing both medical and adult use cannabis. You know, Treasury has said we're going to come out and issue guidance for how you do accounting around that. We think that's going to come after the ALJ hearing and potential reschedule, because if cannabis more broadly is rescheduled, they won't need to do that. But there's a clear recognition from the federal government that people are doing both and are going to continue to do both. And we really don't think it's a gotcha. And we do think that there's going to be diversion is their biggest concern. And it is right, Mitzi, that it is, from the DEA's perspective, you have a Schedule I drug being produced alongside a DEA registered Schedule III drug. How do you make sure there's not cross diversion? States have thought a ton about that, right? And so maybe your system doesn't incorporate everything now, but I do think DEA will be working with folks. And in other states that have at cultivation, it's not designated, it doesn't get designated until point of sale. One of the things that we're thinking through is, can we treat it as all medical until at the cultivation level or at the manufacturing level, and then it's the retailer that really has to figure out how to keep the separation, and the retailer's already equipped to do that because they have to do that under state law.
I'd love to piggyback on that, Hannah. I mostly represent producer processors. Like I said, I have helped some retailers register, but for the most part in Washington, producer processors don't have an endorsement. They have to get everything needs to be DOH compliant. So our Department of Health has to have basically a separate set of tests. And a lot of my producer processors were already working in that direction where most of their product was DOH compliant. So I said, look, if we're going to do this registration, why not all of it just be DOH compliant? Show that every single product you have meets the medical standard. We can show that to the DEA. We can show that everything has a DOH stamp. Everything that leaves your facility is medically compliant, and they are all going to retailers that have a medical endorsement, like to Chris's point. So at the very least, what they're producing is medically compliant, and it's going to a medically compliant retailer. And at this point, from what we know from the DEA, I think that's the best advice that we can give a producer processor in this state.
I have a follow-up that actually will make me sound less pessimistic about everything. And I'm sorry, again, to circle back to the treaty, but the reason, people have been agitating for a move off of Schedule I based on treaty obligations since it was moved internationally in 2021. And so before that, the US government had always justified keeping it on Schedule 1 by pointing at the treaty. And if you look at the order repeatedly references, and I just say the treaty, there's a lot of international drug treaties, but the treaty references the treaty as justification for moving it to Schedule 3. The problem with that is that the treaty does not permit rec use of cannabis. It classifies cannabis as basically a step under. They don't have the same scheduling system that we do, so it's kind of hard to say, but they removed it from the most restrictive. But if the government is going to rely on treaty obligations, that throws the adult use recreational process that is upcoming into a little more uncertainty. And I'm going to circle around and make this pertinent now. The reason that matters is because some people are thinking, well, I'm just going to wait because rec is surely going to be, downscheduled, and then this will all be a big one single thing. And that's not assured at all. I don't know how they're going to do it. It's a terrible mess. I can't, it's not the government's fault that this is a crazy thing. But if you do, again, to the other panelists' point, if you do feel like registration is something that you would want to do, don't not do it because you think rec is coming down the pipeline, because that's going to look, I don't know nobody could tell you what that would look like, but it's not assured, in my opinion. So.
Well, and I think registration is different. Conservatively, to make sure, our advice to folks is if you want to take a conservative position and make sure that the IRS recognizes you as Schedule 3 for purposes of 280E not applying, you should get a DEA registration. But the DEA registration is separate from the rescheduling. And so there is a universe where, and again, I listed off a number of benefits that are separate and apart from the tax benefits of rescheduling. There are a couple of potential scenarios with adult use. It could not be rescheduled. It could just be rescheduled, but there could not be this legal pathway. It could be rescheduled and there could be a legal pathway. If you look at Europe, a lot of the European countries run these pilot programs, right? So it's medical and research purposes, and those are their adult use. So there are ways, or you could be like Canada and be like, we don't care. So there are, and maybe it's an FDA license, or so there are kind of a series of different scenarios that could play out. I mean, we could enter into January 2027 and we could have medical operators that have a path to that are federally legal and rescheduled, adult use that's rescheduled, but it's not federally legal, or both could have the same status. And so there's a lot of unknowns there, but I do just want to make sure, at least my understanding is, rescheduling is different than this DEA registration.
So I knew this was going to happen. I was going to prepare 7 or 8 questions, and then we were going to get through one question, and then it was going to be time to go to the audience. But I think I'm okay with that. I want to thank you all. This has been such a really helpful conversation. I think I want to pull out a couple of audience questions that have gone along with the discussion so far. In particular, I think about that closed loop system. There's a question in here about assuming you can only then medical to medical only. I would love to hear a little bit more clarity on, does that mean registered DEA registered Schedule 3 licensees to registered DEA licensees, or is that just medical to medical, and is that sufficient? And then after a little bit more clarity on that, when you're in the application process, because if you're doing this, and is it safe to call it a safe harbor window, the 60 days, you're allowed to continue to keep operating. At which point in that in the 6 months that they've promised the expedited processing, do you need to enter into that closed loop? Is it the moment you submit your application, you need to be operating as if you are in that closed loop, or is it you wait until you hear from the DEA? Where is that sort of bright line? I'll turn it over to you all.
Those are very good questions. If anybody else wants to jump in,
I
please
have,
feel free.
yeah, I
But
have a couple of thoughts on that. So I think if you look at the application, or at least the new application for dispensary, which we think the new applications for manufacturing and cultivation will probably request similar information, you have to list your suppliers and you have to list their DEA registrations. They don't have any, right? So it's NA right now for everybody. These are annual renewals. And so we think that that is how it's probably going to be solved, that it is when you go and file your annual renewal, you are going to list your suppliers and you're going to be listing either their DEA registration or potentially pending. Like, we haven't thought through what it's going to look like when people are in various stages. But I think that, between when you're and so if your registration issues in October of 2026, your renewal will be October of 2026. So we think that is kind of the window for folks to be able to kind of get operational before there is a filing with DEA that shows that you're working with DEA registrants.
yeah, and just to jump back and answer sort of the top level question, what we mean by closed system is DEA to DEA, not medical to medical, right? We're talking about DEA registrants to DEA registrants. I think Hannah's take is absolutely the most reasonable, that you are going to continue operating during the pendency of this application, which means we assume the DEA recognizes that means you are going to be getting product from non-DEA registrants during that window. We don't know what that's going to look like. I know that some, and Drew, maybe you've got insight on this. I know that some licensees in the production and processing side are applying under the existing forms. I think it's 225 for manufacturing and those things. We do anticipate that the DEA is going to have a kind of a similar medical marijuana manufacturer or medical marijuana cultivator license that comes out in the future. We don't have those yet. I know that some folks that we're working with are taking the position that they would rather get in line as a producer processor now under the existing forms, just to keep their place in line in this 60-day window. I think it would also be reasonable that the DEA will say, okay, here's our official medical marijuana form for cultivation or for processing, and then have an additional 60-day window. We don't know that for sure, but based on the way they did this, I think it's reasonable that you could do that. I also think it's reasonable, if you don't want to take the risk, to just apply now.
I'm 100% with you, Chris. I think when I talk to any of the producer processors on this, they want to get in line now. And my answer is, are you okay with throwing about $800 in the trash? Because you might be. Because that new application might come out, you might have a new 60-day window, but it's not that much money to make sure you're holding your place in line if that's not how it works in the end. Because it's really just the application fee plus what they have to pay me if I'm helping them through it, right? And that's just not that much money for a lot of the producers and processors, at least the bigger ones. I know for the smaller ones, it's a lot to ask. But at the end of the day, it's a price to pay to get in line. And they want to get operational now. And like you said, I think the closed loop system will be DEA to DEA in the end. And right now, the best thing you can do is try to make it medical to medical earlier. And if you're a producer processor, start getting that DOH stamp. It's not that much additional work. It's just a couple extra tests. It does cost a little bit more. And retail may, in the end, have to bear a little bit of that cost. But in the end, it can end up being a tax break for everybody and make this a lot easier for everyone and prepare us for potential federal legalization. And we don't want Washington to be left behind. We hope that the state catches up. We hope that the LCB actually takes some action to give us some clarity that we can be prepared for that. And right now, I think the best thing to do is to jump in line and start getting the DOH stamp if you're a producer processor. Again, it's a personal opinion, not legal advice, but that's what I would do if I were an owner.
There may also be a transition period. I mean, that is speculative, but we have seen it when other products have changed schedules, that there was a period of time to sell out product that you have already to become fully compliant. And so that would be operating within the closed loop system. I have no idea what that timeline would look like, but I imagine there'd be some sort of transitional period after registration, especially because although some applicants are applying under Form 255, there are certainly some applicants that are holding off and waiting for that new window to open. And so we're going to see retailers registered likely before we're going to see all of the
absolutely.
producer processors on board. So there's going to have to be some sort of transitional period.
Yeah, that's a fair point. I mean, when you have retailers and they don't have any way to get product from a licensed producer processor, it's going to be a serious problem.
One of the
Hannah,
things
you reference, oh, sorry, you were about to talk anyway. So you go
Yeah,
ahead
can I
and then I
just
have a
quickly
question
say
for you.
this? Yeah, so one thing that we are telling our clients is like set a drop dead date. I mean, you can't even file cultivation right now, right? But set a drop dead date and consider whether or not to file under the existing forms. What we think is going to happen, both from DA experience for research, but also what we're starting to see already from applications that we filed early on, is requests for supplemental information. And so they give a 5-day turnaround. And so what we're telling folks is if you file using the existing, collect all the information that's required on the retail. So you have it like your employees and the criminal history stuff, so that if they come out, because I don't think they'll just cancel or revoke licenses if you file, because they've already said you can use those forms. We just think that it's possible that they may send supplements to get the additional information. That's just from like what we've seen, because we've filed like 450 at this point and some pretty early on. So we're starting to see responses. But that's our guess. Sorry, Mitzi, you have a question?
No, I wanted to ask a question. So
Yeah.
you mentioned Treasury guidance earlier.
Yeah.
But we didn't really hear what that was. Would you
So
would you explain that real quick?
Yeah, so the same day that the order came out, the Treasury issued guidance that said for purposes of 280E, they are treating the rescheduling as retroactive to the beginning of the tax year in which the order was issued. So if you're on a calendar year to the beginning of January 1, 2026. They also indicated that there's more guidance coming for companies that do both adult use and medical, for them to figure out how to do their accounting if you do have a product that is Schedule 3 versus Schedule 1, and that's to be determined.
And so I bring this up because something that I would tell anybody who called me was to circle back to my little wordy obsession here, is that it says the order actually says that holders of state medical marijuana licenses will no longer be subject to 280E, basically.
And then
And
says
so-
we don't have the authority. It's up to Treasury.
Well,
then.
and then that, and so then the question, I would talk to your accountant about how, because I would think that over time that person would be well informed about anything that happens after this webinar, about what further guidance comes out, whether or not the registration, if anybody ever says, is required for the 280E break, et cetera. But that's a good thing to poke your accountant about and ask them to contact you if they hear anything, so that you can do proper, to the extent you can, proper tax planning.
It is also worth reaching out to folks. I don't know if folks in Washington are taking non-280E positions. I think that it's worth reaching out to tax attorneys and to accountants to see if the rescheduling and the Treasury's guidance to make it retroactive based on nothing maybe changes the risk-benefit analysis of taking that position in 2025. And so it is something we're encouraging our clients to be considering.
Yeah, same. It's something that we're working with a couple folks on, particularly in light of kind of what we've seen from the Treasury so far, and certainly as we get further guidance.
We do have a couple of questions, and there's some confusion a little bit. And just for clarity, if you haven't gotten on the portal, the manufacturer application is not available. Just want to make sure everybody understood that from the discussion. And then there's a little bit of concern about the fee, that there's a different fee, that it's going to be in the $3,600 range, so significantly more expensive for producer processors if they are waiting and that manufacturing portal opens up in time, that cost is going to be quite a bit higher. Does anybody have any insight on that?
Yeah, that manufacturing fee is for the Form 225, which is the currently existing form. So we don't know necessarily what the fee is going to look like for the medical marijuana manufacturer form that the DEA, we've been told, is going to put out there. So we don't know exactly what that fee is going to look like, but I think it's like $3,700 almost. I think it's $3,699 for the 225 form manufacturer.
Okay. Um, so there are also quite a few questions in particular about the disclosures that you will have to make, especially around employees. And so what constitutes an employee? Where is the line on how many folks you need to sort of turn over? And then also a little theme in here too is especially in some of the record keeping for the DEA. Is that a state database, or are you turning patients' information over to the DEA? And then I think there's one question in here that just sort of says, why on earth would we trust the DEA with any of this after the decades of not trustworthy behavior? And so curious to hear in particular about those disclosures, and then especially around disclosing employee information as a part of the application process.
Yeah, if people don't mind, I'm working with a couple clients on exactly the employee issue right now, so this is kind of fresh in front of mind. It's a lot of information to disclose. So, one of the primary issues that we run into is the conflict or tension, I guess I should say, between Washington law and providing this information to the DEA and the DEA requirements to do it. Looking at it, I think it's very much defensible, but the recommendation that we're making to our clients right now is that you have your employees do an attestation about their previous criminal history to get that attestation, right? Get that in writing and then submit with the best information that you can. Because there's so little guidance and we're kind of doing this all in very real time, the goal, I think, for anybody submitting is to give a reasonable good faith effort to comply with the language of the application and the registration, and then supplement as necessary. I think, Hannah, we're seeing the same thing, that the DEA is following up and asking for supplemental information. You have some time to provide that. It is not very long, right? 5 days, particularly if you're turning over a lot of employee information, is not a lot of time. But the attestation gives you something to hang your hat on to say, look, we solicited this information from our employees and we went from there. I think from a Washington law perspective, and I'll just highlight again, this is a very case by case specific analysis. So the recommendation for sure is talk to your lawyer, address these conversations individually, figure out how you're going to address these, because some of them, right, we can't do a one size fits all for these employment issues. But I think the best thing that you can do is do these attestations, get essentially employee buy-in on having this information submitted, and then navigate what happens on a case by case if somebody's not comfortable with that. And you may very well have people not comfortable with that, right? But at a very high level, I think that's how you address the employee issues, and then definitely talk to your employment lawyer, or a lawyer with employment experience about what do we do on a case by case.
And let's also just clarify that it's not, we use the term employees colloquially, but the application isn't limited to employees. It's every person who will have access to the controlled substance. So that could be, that could be much broader than just employees, generally speaking, independent contractors, but anybody that's going to have access, if you have some sort of management arrangement, which are not uncommon in Washington, that everyone who works under that management or consulting agreement would also have to be listed here. And we in California have, for all of our applications, have just developed, like Chris said, an attestation with a clear disclosure authorization statement in it that the employees have to sign. Not only that allowing you to then divulge this information, but also that rep and warrant that the information they're providing to you is accurate.
I want to talk a little bit about what you imagine might get a business disqualified or a denial, what the consequences of receiving a denial could be, what are the risks of going through this application process and then receiving a denial. I've also had lots of questions about, can you rescind your application so you do get approved, and then on the other side of this, it makes sense to just continue to sell Schedule 1 as we have been doing, and you want to turn in your registration. What are the considerations? I know that was like four separate questions, but
I can answer
what
your
are the
last
considerations
question.
there? Yeah.
Yeah, Caitlin, I can answer your last question just because we've answered this for clients. So the rules around DEA registrations provide that the ability to withdraw if you are given notice that there's going to be a denial. In addition to that, once you've been issued a DEA registration, if you cease operations, there's a Form 104 that you can file to essentially voluntarily turn your license over. We have not seen any indication that the federal government is going to change its non-enforcement position with regard to adult use cannabis. I think that there is a question about whether or not the federal government, which has now created a path to federal legality, whether or not they will then take a position of non-enforcement for folks who do not choose that path. That's a little bit different, but we haven't seen anything to suggest that they're planning on changing the non-enforcement position for adult use. But so there are opportunities if the DEA comes to you, they would give you notice and say, for X reason, we're going to deny, you can rescind. And once you have it, if you decide it's not a good business decision, then you can voluntarily withdraw it or terminate it.
And we're telling folks exactly the same, which is you'll have a sense if it's not going well, right? If you get a denial, you have to disclose that on future registration applications. So that to me is the biggest reason to go ahead and rescind. If you get a sense it's not going to work, you're probably better off rescinding so you don't have to disclose in the future. And it's not necessarily immediately disqualifying. It'll give you an opportunity to say why the application was denied. But if you don't have to jump that hurdle, you might as well just knock it out of the way early.
And it's a public interest analysis. I mean, it is the case that for other DEA registrations, a felony conviction related to a controlled substance can be disqualifying, but they do issue variances even in the context of a pharmacy. And it is possible that they just defer to, I mean, there's so much deference to state law, you guys know, and perhaps this is part of your social equity application in Washington as well. Like there are states where you have to have a criminal conviction related to cannabis in order to get priority or be a license holder. And so, it really, there isn't, as far as we can tell, there is not one thing that is an automatic bar, that it is this analysis as to whether or not it is there is a public interest reason not to. Diversion is a big concern. That's kind of the one of the primary focuses, but.
And I'll just toss in one thing in addition to that. I would think of this as analogous, and I want to be clear, it's not exactly the same, but think of it as analogous as the criminal history reporting for the LCB, right? You can have some criminal history, but it's a bigger problem if you misrepresent it or fail to disclose it, right? So if you have something on there that they are asking you to disclose, I think you are better served disclosing it and explaining it than you are hoping that it doesn't come up on their radar, right?
Hannah, you mentioned social equity. And so I was sort of explaining to Hannah also before this call about how the Washington State has just handed out quite a few social equity licenses in the last year and a half. Was pausing on how many are operational, which is not many yet, which means a lot of folks don't have a license number yet, and may very well be intending to operate as a medical operator, but are not sure how to proceed while they're in the process with the state, and what that means for them in the context now of the Schedule III registration. I think there's an opportunity here for the state to provide some really significant guidance on what that might look like to assist applicants. But I'm sort of curious to hear what thoughts you all have, in particular about Washington social equity licensees, also especially about these disclosures. Yes, Hannah, that having prior convictions was a factor in the metrics that issued the licenses or didn't issue the licenses. Curious to hear what your thoughts on that are.
I wanted to actually ask Chris and Hannah to drill down a little bit on that question. You were talking about, well, go ahead and disclose it. Definitely, if you're going to apply and you're going to disclose, do it properly, right? It's not going to benefit you not to.
Well, there's
But
an express is one of the reasons they can deny is if you provide misinformation or fail
Right.
to disclose information accurately. So
Right.
they
And
can
so
deny.
if you are going to apply, I'm wondering if y'all have heard even DEA guidance about what exactly would rise to or fall below, some sort of criminal conviction that would foreclose you or lead to a denial or not lead to a denial, either way.
So felony convictions related to a controlled substance and likely felony convictions related to a controlled substance that are close in time. Because again, they're worried about diversion. And so there is an opportunity, Chris and Drew, you guys are filing, if you put in for an employee that they have a criminal history, you have an opportunity to explain what that is. In our conversations, DEA field investigators give different advice sometimes, but we've been advised, we're not putting too much information in, but if it is a serious offense and it might be helpful to add information about rehabilitation. And so again, we don't think, at least right now, that there is anything that is, this is your conviction. You're not going to get a registration. But we are advising people that if you have, particularly if you or anyone who has access to the controlled substance has a felony conviction related to a controlled substance, to connect with your lawyer and be really thoughtful about kind of how you frame it, the additional information that you provide.
I'll just jump in, Drew. I know you've got thoughts on this as well, but what we're hearing unofficially is that there are no automatically disqualifying questions. You're going to have an opportunity to provide more information, which was something that certainly I was really worried about when the form first came out, right? Which of these is going to be an absolute death knell? And it sounds like the answer is maybe nothing.
Well, I'm trying to figure out just, when obviously it's the, drug felonies that are typically going to be the problem. And people who've been operating, for a while
The
have
conviction.
obviously
It's a
a higher,
conviction.
I'm sorry, what?
It's a conviction.
Okay,
So-
conviction. Are more likely to have those than MSO execs, let's just say. Like that's what concerns me. Like, explain what? Like it was a pot trafficking charge, like, or conviction, so that's why I was asking, because I would think that they would take that into account, but we just don't know, it sounds like.
So for example, if you had a conviction for trafficking cannabis while you had a cannabis license, that is evidence that you are a high risk for diversion, right? And so that is something that is more likely to get them to say it is in the public interest for us to deny. But again, there's a process and they have to let you know, they have to give you due process. If they're going to deny your license, they have to give you an opportunity to provide additional information. There's opportunities within the license application at the registration application itself to provide information. But if you have a marijuana trafficking conviction, I mean, I've dealt with this for a bunch of folks, right? That's 25 years old or 15 years old. You have no other criminal history. You weren't sentenced to jail time. You did rehabilitation. Like all of those things weigh against, denying the application, right? It's highly unlikely that you're going to engage in diversion just because of that. But it's not clear. There's no bright line rule.
Yeah. And I'm with Chris that I'm not sure that anything is going to be automatically disqualifying because it is completely unclear. And with Washington, I will say anything that you can provide with the social equity, because I do represent quite a few social equity retail applicants, and almost universally their convictions are drug related. It's usually, dealing, for the most part, it's usually a conviction, and it's typically cocaine or marijuana. And if you can show how old that is, the social equity license in and of itself is some proof of rehabilitation. It's showing like, look at this, I'm getting involved in this community now. This is a community that I always wanted to be involved in. This is a community that I was participating in before it was legal. And as opposed to trafficking, it was something that was staying local. So the hope is, I don't have any disqualifications. I don't have any warnings or anything like that yet. I don't know that anybody does yet. But I have been asked for additional information, and there's been no indication that those in and of themselves are disqualifying at this point. And I hope that the social equity licenses and the Washington program is enough to show that that is rehabilitation for these people, because the entire point of the Washington program was to give people that were systemically shut out from this industry a chance at it, and for the feds to just come back in and say never mind would be tragic.
Sorry, Drew, I didn't mean to leave you off the list, or Alexis. You guys aren't on my little bar up top,
Oh, you're fine.
but I didn't include your name, so I apologize.
That's fine. I understand. There are some practical considerations too, just for social equity applicants. These second round applicants are, they're not truly applicants right now. They have an invitation to apply, and until they apply to the Department of Revenue, which requires having a location, there really is there's nothing there for you to be able to apply for DEA registration. There's no location, there's no license. You don't even have, some of them don't even have an entity formed at this point because they're still working out the specific logistics of what that ownership structure will look like. So they may be left out to some extent just because they definitely won't fit into this expedited period. But those who already have licenses, if they choose to apply, they can definitely participate, provided, the typical, what is it, CFR 1301 that says that, generally speaking, the DEA can't register somebody who has a criminal conviction, provided there are modifications for this particular program in place.
And Alexis, to your point on the people that, because I do represent some second round applicants too that aren't all the way through. Um, I know a lot of them, at least from my perspective, are looking at this and saying, hey, if we could get a location in time for this expedited period, and if we could get this set up, we could be some of the cleanest applicants in a lot of ways because we haven't been operating in a retail environment that's doing adult use yet. We could just come in and say, no, our plan is to be entirely medical. And I'm not sure if you're looking at that the same way for these social equity applicants, but it does seem like it could provide an opportunity, provided that they're not disqualified for the criminal history.
Yeah, that's actually a really good point, Drew, is that, they can then honestly answer, some of these questions, these liability questions differently than other applicants that have been operating for a longer period of time. I think it may take the LCB's action to some extent, though, because they'll need a license number. They'll need maybe a provisional license of sort to be able to submit that within that 60-day period. If we can get that going in time, something along those lines. Who have a location, have submitted to DOR, but don't have a license yet. Something in that interim period they can use for their application.
Yeah, so to Alexis's point, if anybody from the LCB is listening, that would be very helpful.
I was also going to plug the work that Caitlin and the Cannabis Alliance are doing, right? I know, Caitlin, you are working on some of these things and have been in touch with some of these offices. And so I think one of the questions you posed to us as we were preparing for this panel was what might be helpful. And I think that's a really clear one. Clear indication from the state that Washington licenses are mixed use, right? They're not solely adult use or recreational, that they are mixed by virtue of the medical program we have in Washington state, and then getting out some license numbers to try to help some of these folks who are in these second round applications or don't have locations or might have an opportunity to do that. So anyway, agents from the state, if you're listening, respond back to Caitlin's letters and we'll try to get that rolled up.
Yeah.
I believe that they are. So thank you everybody for continuing to sort of push for that guidance. And I think we've got a question in here from a social equity applicant who does not have a license number yet. And the question is, what should I be doing right now? And I think that says a lot about everything that we're talking about, because really it's the state that needs to be doing something. And so continuing to ask for that guidance or that support for social equity applicants and then licensees in general, I think is a really critical part of this process. Wendy Hall, I see you have very patiently had your hand up to ask a question. Go ahead. And gosh, I think we're going to do some fun administrative something here. Let's see. Oh, I lost you, Wendy. Okay, go ahead, Wendy.
Let me unmute. Okay, can you hear me?
Yep.
Okay. My name is Wendy. I own a producer processing company called Fairwinds, located in Washington. You know, a lot of people have asked me if I've put in my application yet for this, and it really feels like it's the cart pulling the horse. I mean, I know the order has been issued, but there are no regulations that or anything really concrete. So I'm not clear on what the pros and cons are for actually applying, and it feels really like a risk to me to apply for something that I don't really know what I'm applying for. So, you know, I don't claim to know everything about this. I've talked to a couple attorneys, but I'm just very hesitant to even apply when there's no regulations that are written. And I'm not sure what the process is. I know you guys have talked about this in terms of if the rules actually do come out and it's something that I don't want to be a part of, because I don't want to pigeonhole our company into something that could limit us or could have negative effects on our company. And the devil's in the details. So until I see something in writing, I'm very hesitant to even apply for anything with the DEA. So I don't know. What are your thoughts on just the application process being open without rules being written and regulations written? And I'm not even sure how the Liquor Control Board could write any rules when they don't, what are they writing it on? I mean, doesn't something have to come out from DEA first before they can write any kind of regulations around this?
So could I field that one first?
Yeah.
So DEA registrations have been around for a long time, and there's actually a kind of a really robust regulatory framework for DEA registrations. And so it is that provide helpful information about like your ability to rescind during the application period, your ability to kind of voluntarily surrender once you're licensed, like that. There are lots and lots of regulations already in place for DEA registrations. This is, you know, the thing about this DEA registration that is unique is that state law is really going to continue to govern from an operational standpoint. And so while there are certain things that your state regulators can do to make it easier for you to show the DEA that you meet these criteria from an operations standpoint, I mean, the way that we understand that the vision here was is that, you know, DEA wanted to have the ability, if there is, like Chris said, a clear violation of the Controlled Substances Act and the state is not doing anything about it, to be able to come in and revoke the registration. But otherwise, an enormous amount of deference was going to be given to the state, and that folks were really going to be able to continue to operate under state law without changes, unless you're in a place like Maine with no tracking or testing, you know, as they had before.
But at this point, aren't we kind of guessing? I mean, we keep talking about like in theory, but there's nothing in writing yet.
Well, the order is
Right.
also a rule that was published in the Federal Register. So the order itself is a rule that's published, and then there's an additional body of federal law that governs DEA registrations.
I think it's interesting, Wendy, because first of all, those are the rules, and that, you know, that it's amending the rules and adding to the rules. But this goes back to kind of my initial point where it's unclear what the benefit is. It's speculative both ways, what the benefit is and what the negatives are. There's, you know, conservative ways to read it. There's, you know, textualist ways to read it. There's all kinds of ways to read it. And it just really depends on your circumstances and whether or not it's going to benefit your business. But what that order does kind of fail to do is say, if you don't, now that doesn't mean they're not going to do anything. We don't know, but it doesn't say if you don't. But how, you know, how much do you want to gamble on that? How much are your other people going to be registering, since you're a producer processor? Are the retailers that you work with going to register? That's, you know, probably going to influence it. And that might actually be why, separate from maybe bureaucratic reasons, that the next round, that you know, first they're doing the retailers and then they're going downstream to the sources. And so I feel you on that. And I keep asking people, what's the benefit?
Well, and I agree with you, Mitzi. You said the key word, and that's speculative. we're speculating right now. Nothing is in writing. And I can't tell you how many times, just as an analogy, that I, in theory, supported a bill, but until the words were written on paper, I don't really know if I support that because the devil's in the details. And so right now I'm speculating on whether or not I would even want to apply for this because I don't really know what I'm applying for. I don't know the pros and cons, and I would like to see that in writing before I just take this leap. I don't know. Am I off base?
Alexis, I saw you come off mute.
Yeah,
Yeah.
I apologize. And let's remember, Wendy, this isn't a 60-day application window. This is an expedited application window. Nothing prohibits you from sitting back and seeing if in a year you still want to apply, right? And so that's a choice you'll ultimately have to make. And there are some questions about whether or not that may require applicants to cease operating in the medical industry during that interim period. I personally don't think that it does. I think that it provided you're operating within state law requirements, you will be able to continue to operate. But that's sort of a discussion point that we can have, brought up here. And if anybody wants to chime in on that, feel free. But yeah, sitting and waiting is always an option.
And I think there are definitely benefits to applying now. I think as we've discussed, there are definitely some clear benefits to applying now. There are maybe some benefits to waiting, but the analogy that I've been using is we're trying to build this plane as it's flying and we're trying to land it. And frankly, the DEA is still laying tarmac as we're coming down, right? Everybody is figuring out together how to do this. But I think it's really reasonable to have concerns. I think it's really reasonable to have questions about what this will look like practically. And we have a panel today of 4 very intelligent people plus me that all kind of come out on this in like a little bit of a different place. And we've all been doing this a long time. We all read the order and read all the associated documentation and are doing this every day. And everybody's coming out in a little bit of a different position. So I think that's reasonable and frankly appropriate to be a little concerned.
And I do just sort of want to put a little point of clarity on it because, we're used to our state process where a law is passed and then there's a rulemaking process and there's requirements of engagement and interaction. And some of that applies here. But again, there's been lots of mention of the treaty, as it's also mentioned in the order and the single convention. And there's a whole bunch of super nerdy, really academic, interesting stuff about how that process exists. And I believe that's a part of some of the legal challenges to what's happening. Is involved in all of that. But there are things written down right now. What I think the speculative part is how those written things could be changing in fast order. We don't know that. So what we can work off is the written in law things that we have right now, with the understanding that they are maybe they could be. There are opportunities for them to change fast and soon. And so, the idea here is, do you want to go off of what's written right now and make and jump into that boat? Or are you hoping to get greater clarity, more definitive, something different in the upcoming proceedings that we have in front of us? Would you all agree that that's a fair characterization?
And we're supposed to be getting more information soon, right? From what we're hearing from various sources of reporting is that there's supposed to be more information coming. There is no guarantee that it will come before you need to submit an application for the 60-day window, but we have been told, again, unofficially, that more information should be coming.
I do see that we are at 4:24. I see some really important hands up, and I'm so sorry we did not get to all of the questions. We will follow up this webinar with everybody's contact information who is on this panel so that everybody can feel free to reach out and talk about your individual situation and get a little bit more advice to help you sort of move through that process. I would like to leave see we've got about 5 more minutes, and want to turn it over again to our panelists to just sort of give us a quick, just sort of final takeaways and closing thoughts for folks as they're really sort of mulling over. And then I would like to ask, if the state of Washington were so inclined to do something in the next week, what would your recommendation be to our policymakers who might be listening to this? And we'll go in reverse order. So, Drew, we're going to start with you. We'll go Drew, Mitzi, Alexis, Chris, and then Hannah, if you wouldn't mind closing us out.
Sure. So I guess my little tidbit to leave it with is I'm still pro applying because it's not going to get easier. And it has nothing to do necessarily with cannabis or the fears or things like that. But Schedule 3 is probably going to be here to stay. It's a federal government action. It's unlikely that they're going to undo it. And it's not going to get easier to do administrative things like this in the future. It's not going to be a faster process. They're going to probably look at your company with more scrutiny as time goes on. And if there's anything that the state could do in the next week, it's provide more clarity for everybody who is applying. Just simple emails. Help out our retailers and our social equity applicants who don't quite have a license number. Give them just an email with an official like AG address or an official governor address that shows, hey, this person is qualified. Because right now that might be enough to show the DEA and keep an application going in that portal until they get more information that they need.
Thanks, Drew.
I mean, I agree with what everybody is saying about what the state can do. But what I do want to say, again, after kind of some doomsaying, is that, you know, if you had told me 10 years ago that I'd be sitting on a panel talking about how tricky it is because it got rescheduled and the feds are gonna, you know, be part of I wouldn't have believed any of it. And so I think that it's a good thing to step back and realize, like, no, I do not think the DEA is going to come in, you know, stormtrooper style. I don't. It's a tangled bureaucratic situation. It's uncertain, but the big idea behind it is pretty amazing. If we all kind of step back for a second and look at how we're all so, you know, how to do it, why to do it, where to do, you know. But man, you guys, like, a lot of you have worked very, very long to see this, and that's pretty great. So we're all going to do our best and keep moving forward.
Thanks, Mitzi.
I think it's my turn. You know, I've already kind of mentioned some of the things that we would like to see from the state and from the LCB. But, you know, administration moves slowly, and there's not a lot that can honestly be done and accomplished within a week. But what can happen within a week is for the LCB to have discussions with license holders to understand their concerns, to maybe formulate some processes moving forward, whether it's emergency rulemaking or potentially, you know, suggesting some statutory changes, but just have discussions and just engage in that with license holders. And we've seen in California, for example, the DCC engaged in these discussions, created emergency rulemaking that made the process more streamlined. And, you know, we just haven't seen that here in Washington so far. And I'm not trying to badmouth the LCB by any means. They have very difficult jobs. But, you know, I think that stakeholder engagement is very important.
Thank you, Alexis.
I will definitely echo Drew and Alexis's points on that. Getting something official that says Washington licenses qualify as medical endorsements under our rule set, getting clarity on that is going to be really helpful for people that want to apply, and it will eliminate that ambiguity. At the risk of sort of, I think we've hit that pretty hard. So I think I'll go back to a slightly different takeaway, which is, you know, 30 seconds or less. What's my recommendation for people considering this? The easy throwaway, so I'm not going to count it, I'll give you two, is call a lawyer and talk about your situation, your business, what you want to do, your concerns. That's takeaway number one, because this is happening in real time very quickly. And then the second is look at what the application is asking. Even if you're a producer processor, I think the best information we have is that these are going to look really similar when those forms come out officially. Look at the application, start thinking about what it's going to take to do that, start thinking about the resources you have to start pulling that information together, any issues that you might run into. And you don't have to submit until the 26th to get in the window if that's your goal, right? If you're going to wait, disregard that, right? You don't have to submit until the 26th. I will just add the caveat that we are seeing some reports now that the portal is crashing because applications are either so large or there are so many people trying to access them. So I would just caution people, don't maybe wait until the 26th at 11 o'clock to go ahead and try to submit in case it crashes. Think about this now so that you have some runway to do it.
So I think the thing that I would say is that we have all been operating in this environment of discretionary non-enforcement. The federal government, the Attorney General, Jeff Sessions, Pam Bondi, Todd Blanche could wake up on the other side of the bed and decide to enforce the Controlled Substances Act. If you have a DEA registration in hand, you are operating a federally legal business. You can sleep at night, and you know that as long as you're not violating the Controlled Substances Act, you're going to keep that registration and you're going to keep your business. And that to me is a pretty remarkable thing. I think we all have gotten very comfortable with this position of non-enforcement. And so it feels like they've let us do it forever. It's not going to change. There's no guarantee. And so that's one thing that I want folks to consider. This is scary, but I feel like it's a little bit like hemp. I watch all these hemp people say, I don't want FDA regulation. I don't want FDA regulation. My view is if the FDA regulates you, you're legal and you can do it and you can build your business. And otherwise, you're at the whim of whatever administration is in there. And so I view it that way. It creates certainty in a number of different ways. So that's what I would sign off on.
Thank you all so much. I deeply appreciate this discussion, especially some of the disagreements. I know that for those of you who are attending, that was about as clear as mud. So sorry, that is the reality that we are currently in, but hopefully this is giving you a lot more to think about as you're considering what to do with your own business. Here at the Cannabis Alliance, we of course appreciate your support. Like I said, we're going to have a follow-up email that will give you some opportunity to donate so we can continue to do work like this and seek clarity on your behalf in the state of Washington. And then also we have a golf tournament coming up in July. If you'd like to register for that, we'll include information. It's a really good time. We're still taking sponsorships as well as foursomes and twosomes to come play out in Leavenworth. Again, thank you everybody. Really appreciate your thoughts. Thank you everybody for in attendance. I hope you have a great rest of your afternoon. Take care, everyone.